that is the case, the judgment has been delivered.
Yes.
The person has gone home. The person has paid the fine and gone home. You are the NJC. You are looking into this matter.
Yes.
Aside looking at the law and the fact that the person is not serving maximum sentence, I mean, according to even the section that you read, that you could serve an imprisonment term of up to 2 years.
Yes.
Or a fine, or both.
Yes.
How come the judge, did not look for the maximum just to send home a statement?
You know the reason why? The reason why is because when this law that I just read out to you did not anticipate the concept of plea bargaining. It did not say that there. Now, plea bargaining came from somewhere, which we have adopted over some years now. Now, and plea bargaining says there must be an agreement between the prosecutor and the accused.
But we did see the prosecutor wash his hands of that particular judgment and say that we saw the prosecutor shortly after the judgment was delivered.
Yes.
The EFCC claimed ignorance of any plea
what
bargaining
else would
arrangement.
they? It is when we analyze things like this that we should be able to see who gets the blame and who does not get the blame. I mean, what would they say? They would say, oh yeah, we are appealing, we are doing this. It's a big lie. What? Why in the first place did you replace the first charge sheet, under section 315 to section 309? That's number one. And again, the plea bargaining that you brought in, now, was that not supposed to be an agreement between you and the defense lawyers?
Okay, so what that means is, when there's a plea bargain,
yes,
you cannot get maximum sentence.
You can't get maximum sentence.
Okay, so now that there was plea bargain,
yes,
so wherein does the discretion of the judge lie in spite of that plea bargain? Because the FCC says here, in that reaction at the time, they say that it runs contrary to the understanding between prosecution and the defense.
Yes.
Wherein the convict consented to a custodial sentence.
Yes.
With the forfeiture of all assets and money that are proceeds of the crime. So they think that's something that the judge, even though he still had judicial discretion,
yes, did
not utilize it properly based on the agreement of custodial sentence.
How else would the judge have used his discretion when there was plea bargaining? And again, you're asking how would he have exercised his discretion?
Perhaps they think that if there was an agreement, which his lordship was privy of, so they expected that agreement was what his lordship was going to deliver.
You see, I'm not sure that what the NJC should discover or must have discovered is that the plea bargaining agreement was not respected by the judge, which is most unlikely. It would be most unlikely if there was plea bargaining, and the thing was to the fact that he must surrender all his properties, and they were so surrendered. And the judge was to exercise his discretion in view of this surrender. That is to say, there must be no maximum sentence. So instead of 2 years...
Because that principle is still there.
Yes! Instead of 2 years, he could just do 1 month, 1 day, 6 months, 1 year, or 1.5 years, subject to a maximum of 2 years. He would exercise his discretion in that direction. Or then, fine, okay, he should pay, 10 naira, 20 naira, in view of what accrued from the free bargaining agreement. You understand? So, but if Nigerians, like I said earlier on, if Nigerians have been told that, he was to serve a term of, say, 2 years and a fine of 200 million naira, everybody would have been happy. But that had been realized from the free bargaining agreement. So the judge exercises his discretion in that direction.
But the discretion here again is that, remember then, the 309 is with or without.
Yes, with or without, correct.
So, he could have as well asked him to go on both.
Correct.
Take the jail sentence as well as pay the fine.
But couldn't he, if he had said with one, because it's either one or both.
Or
is that
both,
not so?
yes.
Correct. So if he had said one, he was exercising his discretion. Why should anybody now quarrel with him? In exercising judicial discretion according to law. Because that's the law.
Does that mean that when plea bargain sets in,
it
means that there's flexibility on that sentencing where he says with or without? It means
you have just hit the nail on the head. there is absolute flexibility. Once there is plea bargaining, then it is flexible. Then the judge, in exercising his discretion, must have an eye on the plea bargaining agreement.
But what do you think would have gone wrong if the counsel for the commission was shell-shocked at the judgment that was delivered? Because the commission says, look, this was duly communicated. The agreement was communicated to his lordship. So, in that discretion,
yes,
does he still have the discretion to even go against what was communicated to him?
I like that expression. They were shell-shocked. The commission was shell-shocked. Yes, shell-shocked in quotes. You see, that shell-shocked thing was an afterthought. When they realized the deluge of public reaction, stole billions of naira and, was charged, was fined 250,000 naira for each of the three counts, making 750,000 naira, just like that. And then there was a limousine waiting for him to take him home. When they heard that, they now went to the street protest. We are going to do this. And they were now shell-shocked, in quotes. How can they say they were shell-shocked?
Or more like an afterthought?
It was an afterthought. Did the judge veer away? Did the judge veer away from the plea bargaining agreement? That's what everybody.
Well, that's what the EFCC is claiming, that the judge did veer away from the plea bargaining agreement.
No, but that's what everybody has to find out before we begin to pillory the poor judge. You
claim that the judge is poor. I mean, maybe the NJC will disagree with you in terms of whether or not the judge is poor. I mean, if you look at, you've already admitted that judgment, there was something wrong with it, even though you say
but who is to blame? That is the problem.
You say it was done on law, and that's what you're looking at.
Yes.
If you look at what Chamberlain has read out in terms of the comments of the EFCC and the plea bargain,
is an afterthought,
which you say is an afterthought.
Yes.
What about, you said something about the judgment, the prosecution coming down from where he would have gotten a 14-year jail sentence.
Yes.
And couldn't there have been some kind of agreement as well that we will not prosecute you under this law, we will prosecute you under this law, where we think that, rather than serve 14 years, you'll get 2 years and you get to forfeit whatever it is you need to forfeit. Couldn't there have been the kind of plea bargaining that they had?
No, because it would have been immoral on the part of the prosecutor to shift from the original law under which they were charging this person.
So you say that what they did was immoral right now?
Yeah, very immoral. For example, we have to probe into the whys and wherefores of their shift from Section 315, which attracted a maximum of 14 years imprisonment plus fine. Now, from that one to Section 309. And the judge presided over this case under the provisions of Section 309, not Section 315.
And you say that the judge has no say. I mean, I'm sure the judge is very aware of the Section 314 and knows that there is something stiffer for this person. And, even though he's sitting on the case, and you say that a judge cannot say, no, go back and go and prosecute the person under 314. Looking at the 309 that you have, are you saying that the judge could not have been stiffer?
Nowhere. It's not. I mean, even one is a non-lawyer, you would agree with me that the judge can never dictate to the prosecutor to say this matter you are bringing. The law that will foist maximum penalty on this your accused person is this one. Don't use this one. We've
agreed on that. We're prosecuting you, or he's been prosecuted. I'm sitting on this case based on this law that you have brought.
Correct.
According to moral standing, couldn't the judge have taken the maximum sentence, according to the law under which the person was prosecuted?
The one of 315 had already been forgotten.
Yes.
We are now operating on
309.
309.
Yes.
Now that 309, it was when they were discussing this thing on the basis of 309 that plea bargaining came in.
Let me quickly veer off. Let's leave this 309 debate alone and quickly go to the actions of the NJC.
Yes.
Now you are the NJC. You've seen this particular situation. How would you have addressed it?
I've seen this particular situation. First of all, I must respect the the conscience of the judge to start with. I don't want to